So here's what happened. An ICE chief was asked a very simple question. Why are agents breaking down doors with what amounts to an internal permission slip instead of a real judicial warrant? And instead of a clean constitutional answer, we got case law references, memo explanations, and a defense of something that looks an awful lot like a workaround to the Fourth Amendment. This exchange happened during a Senate oversight hearing, and the moment that stuck wasn't the shouting, it was the framing. A senator holds up an administrative warrant signed by another ICE official and calls it what it looks like. A green light from inside the agency, not a judge. That's the tension. Because when federal agents enter someone's home, the Constitution is supposed to be the guardrail, not an optional suggestion. Let's watch what happened, and then I'll break down what's really going on here.
This picture is of ICE agents forcing their way into the Minneapolis home of Garrison Gibson, banging down the door, detaining Mr. Gibson in front of his wife, Tiana, and their 10-year-old daughter and niece who happened to be there at the time. I don't know whether you're familiar with what happened here. It's one of many, many, many similar incidents that have happened all around the country. And it was done pursuant to what is called an administrative warrant. I'm going to hold up a copy of that warrant, signed by an SDDO, who is, I believe, a member of the ICE workforce, another agent, a supervisory detention and deportation officer, not a judge, correct?
Correct, Senator.
So, in effect, this is not a warrant, it's a permission slip. It's a green light from another ICE agent to go bash down a door, smash into a home, detain and arrest someone without a judge finding probable cause and without any sort of objective, independent finding. Is that correct?
No, sir. So the I-205 is the arrest warrant, but the I-205 is based on an executable final order issued by an immigration judge from the Department of Justice.
And that order is from an immigration judge who is part of the executive branch, not an independent judge. But the warrant issued is simply a permission slip. Now, let's be very clear. You were a local police officer.
Yes, sir.
To bang down a door, barge into someone's home, if you're the FBI or a local police officer, you need a judicial warrant from a judicial officer, a judge, who is going to find or not probable cause, which has a specific meaning under the law. These ICE agents are banging down doors, doing the same thing without that kind of judicial warrant. What is so different about ICE that it regards itself as an exception to the Fourth Amendment? And the requirement for a judicial warrant is a Fourth Amendment requirement.
We don't, Senator. There is case law, U.S. versus Lucas, 2007, which is out of the 8th District of Minnesota, which authorizes the entry of a home to catch a fugitive based on an administrative warrant.
I beg your pardon, sir. It does not abrogate the Fourth Amendment. It does not say that ICE agents or CPP agents can simply bash down doors and barge into people's homes, terrorize their children, detain and arrest people without a judicial warrant. And there is nothing different about what ICE does as compared to the FBI or local police that would justify it. The policy that they're acting under, in fact, is the result of a memo that you issued in May. You're familiar with it.
Yes, sir.
Has your signature.
Yes, sir.
Which says, in effect, they don't need judicial warrants. They can act on the basis of the 205 warrant that you've just described, which is administrative. It's not judicial.
So let's talk more about it.
Why did you keep this memo secret?
I didn't keep that memo secret, sir. It was blasted
Well,
out.
we learned about it when 2 whistleblowers came to us and said that you were using it as a basis for the policy. It was never announced publicly. It was never released to the press or the American people. Why did you keep it secret?
Sir, I didn't keep it secret. If sending an email to a workforce of 30,000 people is keeping something secret, it's a bad secret.
It never reached those people.
Yes, sir, it did.
Well,
The email did, sir. Yes, sir. I can work with your committee to get
let
your
me
staff to get that.
let me move to another topic.
If that felt ridiculous, that's intentional, because what you just watched wasn't just a disagreement over paperwork. It was a collision between two completely different understandings of constitutional limits. One side is saying, this is an arrest under immigration law. The other side is saying, you just smashed into a home without a judge. The discomfort comes from that gap. When the senator calls the administrative warrant a permission slip, he's not making a technical point. He's reframing the authority. And when the ICE chief responds with U.S. v. Lucas 2007, he's not conceding ground. He's shifting the battlefield to case law. This isn't confusion. It's strategy. It's about who defines what counts as a warrant. Here's what wasn't in that clip. Administrative warrants like the Form I-205 are authorized under federal immigration statutes, specifically 8 U.S.C. paragraph 1226 and paragraph 1231, which allow the Department of Homeland Security to arrest and detain individuals subject to removal. But the controversy centers on home entry. Under the Supreme Court's decision in Payton v. New York 1980, police generally need a judicial warrant to enter a home to make an arrest. ICE relies on case law such as U.S. v. Lucas, 8th Circuit 2007, which held that officers could enter a residence to execute a valid administrative arrest warrant if they have reason to believe the person resides there and is present. That's the legal hook. What critics argue, and what was implied in the hearing, is that immigration judges are part of the executive branch, not Article 3 judges. That distinction matters because the Fourth Amendment protects against unreasonable searches and seizures and requires probable cause determined by a neutral magistrate. Reporting from outlets like NPR and the Associated Press has documented increasing tension between local communities and ICE operations involving home entries based on administrative warrants, particularly in mixed-status households. This isn't theoretical, it's a live legal friction point. Let's slow this down and separate emotion from law. The Fourth Amendment states, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. In ordinary criminal cases, law enforcement needs a judicial warrant issued by a neutral magistrate to enter a home. However, immigration enforcement operates under civil, not criminal, authority. ICE administrative warrants are issued by authorized immigration officers under statutory power granted by Congress. Congress has Article 1 authority to regulate immigration. That's not controversial. The question is how that authority interacts with constitutional protections inside the home. Immigration judges are part of the Executive Office for Immigration Review, EOIR, which falls under the Department of Justice, meaning they are executive branch officials. So here's the friction. Administrative warrant, authorized under immigration statute. Judicial warrant, issued by Article 3 judge. Fourth Amendment, requires probable cause and reasonableness. Courts have allowed certain entries based on administrative warrants, but the scope remains contested, especially where force is used or where third-party rights are involved. This isn't black and white lawlessness. It's contested constitutional territory, and that's why this hearing mattered. This isn't about one door in Minneapolis. It's about defining enforcement as exception. The senator's strategy was clear: collapse the distinction between ICE and the FBI. If local police need a judge, why don't you? That forces the audience to see ICE as bypassing a constitutional standard. The ICE chief's strategy was equally clear: emphasize statutory authority and precedent. We're not ignoring the Fourth Amendment. Courts have approved this. Two narratives. One says, this is a constitutional loophole. The other says, this is authorized federal law. Notice the pivot moment in the clip when the memo becomes the focus. The senator reframes it as secretive. The chief reframes it as internal guidance emailed to 30,000 employees. That's narrative substitution. One side frames secrecy, the other frames bureaucracy. This isn't about technical legality alone. It's about public perception of constitutional boundaries. If people believe federal agents can enter homes without a judge, that feels like exception power. If the agency convinces people it's legally validated enforcement, that feels like lawful authority. Control the perception, control the debate. Here's why this matters long term. When constitutional gray areas expand quietly, they don't shrink on their own. If administrative warrants become normalized for home entries, the definition of reasonable shifts. That doesn't mean the Constitution disappears, but it does mean enforcement power expands under civil authority frameworks. Oversight hearings are designed to surface these gray areas before they calcify into precedent. If those hearings turn into partisan shouting matches instead of substantive clarifications, the public never gets clarity, only heat, and that's the danger. Not ICE, not one memo, but normalization. Once enforcement authority is perceived as an exception to the Fourth Amendment, even if courts technically allow it under narrow conditions, trust erodes, because constitutional protections rely on public understanding as much as judicial rulings. If citizens can't tell where criminal authority ends and civil authority begins, institutional trust decays. That's not partisan, that's structural. Calling an administrative warrant identical to a judicial warrant is like calling a company memo the same thing as a court order. They may both be printed on paper, but one comes from inside the building. This isn't just about immigration enforcement. It's about how far executive power can stretch inside your front door. If you found this breakdown helpful, make sure you like this video and drop your thoughts in the comments below. Don't forget to hit the bell icon so you never miss when I post new content. Share this with someone who needs to hear it and subscribe for more deep dives like this. Thanks so much for watching.